We are live. So thank you to everyone who's attending today's webinar, Medicinal Cannabis Use and Duty to Accommodate. I'm Jeremy Thiel, the Senior Manager of Marketing, Ideas and Education with DC. And first off, I must say, holy smokes, we've had over 800 people register. So my mind's blown, so wow. And we can't thank everyone enough, and we appreciate all of your support. So the goal of today's session is to provide you with the knowledge and guidance on the considerations that should be taken as an employer when employees disclose use of medicinal cannabis. But before we get started, I'd like to go through some brief housekeeping items, as we are doing a webinar, so challenges do occur. And with 800 people, I'm sure one person's struggling out there. So please note that everyone's on mute, and any of your questions can be submitted at any time during the webinar. You're going to notice a Q&A icon at the bottom of your screen, and you can submit them there. And we're going to try to get as many as possible. If you're experiencing any technical difficulties, the majority of those issues can be addressed by using the up arrow or chevron icon in the bottom left-hand side of your screen. From there, you'll be able to select your proper microphone and adjust any volumes, etc. And again, please note this webinar is being recorded, and we're going to post it on YouTube within the next day or so. But we'll also send out a communication to all the registered guests, giving you guys those links so you can relive the moments over and over. Okay, so let's get to the good stuff. I'd like to introduce our esteemed moderator for today, Dr. Jonathan Davids. So Jonathan's Driver Check's Corporate Medical Director, and he's also an occupational health medicine physician. So welcome, Jonathan, and over to you.
Well, thanks very much for that intro, Jeremy. Welcome to all of our attendees today. We've got a large number of registrants, as Jeremy has mentioned, and so this is probably likely an indication of the topical of medical cannabis use in the workplace. Maybe it's also something that's not COVID, although we've gone through that for the last 2 years. Regardless, Driver Check is very happy to host today's webinar with two very special guests who I'll get to in just a minute. Many of you will already know that Driver Check is a leader in the alcohol and drug testing business, but we also have a full suite of occupational health services, from pre-employment medicals, testing and conducting assessments of regulated medical surveillance programs for injury management, to fitness for duty determination. But I also want to highlight that we also do have a service where we have medical cannabis file reviews to help determine fitness for duty in circumstances like what we're going to talk to today. Today's webinar is really going to be exploring the thorny issues of medical cannabis use in the workplace and all of that comes from that. Following a recent arbitration ruling at the end of last year, we're hoping to have a discussion today to unpack some of those prickly details. To help us do that today, we've got two special guests, a lawyer, Melissa Roth, and a doctor, Melissa Snyder-Adler. But before we get to them, just a disclaimer, please understand that this webinar is not intended for legal, medical, or expert advice. It is a high-level overview. It's impossible to cover all relevant details, and your available rights and remedies will depend on the unique facts of each situation. For specific advice, please contact your qualified legal counsel before making any decisions or taking any employment action. As you all are aware, things change and new medical studies come out with new results and more precision with medical restrictions. So legislation, case law can change over time, and so you're best served by following up-to-date and reliable sources of information. Okay, let's get to it. I'd like to introduce our speakers. First off, Melissa Roth is a partner with Gowling WLG's Waterloo Regional Office. She practices in the Employment, Labor, and Equalities Group. Melissa's worked with private and public sector employers in a wide range of issues, including human rights, wrongful dismissals, employment contracts and policies, and labor law, just to mention a few of them. She's been a great help to Driver Check, and it's our pleasure to have you as a guest speaker today, Melissa. Welcome. I'll get back to you in just a minute. The other Melissa that we have will likely be a very familiar face to all of you joining us today. Dr. Melissa Snyder-Adler is an addictions medicine physician and Driver Check's Chief Medical Review Officer. She's been called upon and recognized as an expert testifying in labor arbitrations and other litigation circumstances on the topic of cannabis testing and impairments. She's a frequent speaker on workplace substance use, including medication and medical cannabis, and the impact that this has had on safety-sensitive jobs. It's a privilege to have her join us today to offer her take on this case that she was involved in. So welcome, Dr. Melissa. Okay, so to get to it then. So what I wanted to do today is just hand this over to Melissa Roth so she can outline the details of this case and get us started, and then perhaps move over to Melissa Snyder-Adler and ask her for her take on the medical bits and pieces, and then encourage just a conversation that goes from there. As Jeremy has said, please, if you have questions, put them in the Q&A. We're happy to explore any of those questions with our two guests. So without further ado, I'll pass it over to Melissa Roth. Take it away.
Thank you very much, Jonathan. It is my pleasure to be here. I think this is a very interesting case and a topic that is not COVID related. So that is a welcome and refreshing webinar, I would say, from my perspective. So thank you for inviting me. I want to tell you a bit about this case. So the case that we're going to talk about is Orange, so the air ambulance service provider, and their union. So it's Orange Air and Office and Professional Employees International Union. I can put the citation in the Q&A. One of us can put the citation in the Q&A so you can find it on Canly. But I'll tell you about the case, what you need to know in terms of the law, and obviously Dr. Melissa will help with the medical part of things. So you may recall that, there was a lot of anxiety regarding legalizing marijuana and the impact that it would have on the workplace. And this is talking about recreational cannabis. Some of you would have maybe seen me doing speaking engagements about 4 years ago in those distant pre-pandemic times when I was doing a lot of speaking engagements about the legalization of recreational cannabis and the impact that it would have in the workplace. And a big message at that time was that the legalization of recreational cannabis has no effect in the use of medicinal cannabis in the workplace. And that is the intro that I wanted to give you for this, because what we're talking about today is the use of medicinal cannabis. It has nothing to do with recreational use of cannabis, because it is only when we're dealing with the use of medicinal cannabis that a disability comes into play. Obviously, if we're dealing with recreational cannabis that causes an addiction, then that's a different story. But when we're using it as a treatment for a disability, that's what this case is all about. So the case is a very interesting decision relating to an aircraft maintenance engineer who worked at Orange and was prescribed medical cannabis for anxiety. In a nutshell, despite considerable efforts to accommodate on the part of Orange, the arbitrator, who is Gail Misra, determined that Orange had not met its duty to accommodate. And in particular, Orange treated medical cannabis differently than other drugs that might impact performance, and therefore its drug and alcohol policy was unreasonable because it had a zero tolerance policy without any exceptions for medicinal cannabis or disabilities. While this case is in the unionized and federal context, the analysis would also apply to any Ontario human rights application by non-union employees, because the legal principles are still the same. So that's also important for those of you who are out there and are thinking, why are we talking about an arbitration? Really, the analysis of arbitrator Misra applies the same way, whether we're dealing with the Human Rights Code or the Canadian Human Rights Act, and whether we're federally or provincially regulated. So in this case, there are two grievances. One is the employee grievance for the failure to accommodate, meaning discrimination on the basis of disability. And the other one is the policy grievance about the employer's zero tolerance drug and alcohol policy. So the employee, as I mentioned, was an aircraft maintenance engineer, which is a safety sensitive position, and it required a number of complex and detail-oriented tasks. There was a policy as well. Orange had a zero tolerance policy for cannabis use in safety sensitive positions, under which a violation of the policy would lead to disciplinary action up to and including dismissals. Employees who were prescribed medicinal cannabis were required to disclose cannabis use to start the accommodation process. So the employee disclosed his use of medicinally recommended cannabis, which indicated, which started the accommodation process. And the employer accommodated in different positions and it engaged in what we call the procedural duty to accommodate. But all of it was initially intended to be a 10 to 12 week plan, but it continued for 6 months until the employer said they could no longer accommodate. So at that point, the employer arranged for an independent medical examination. The griever was given 2 options, and the griever chose driver check with Dr. Snyder-Adler. So that happened in February of 2020 and also in October. What's important is that the parties agreed that the employers had made efforts to accommodate the griever during the initial 10 to 12 week cannabis medication trial period. And then after, it didn't move quickly to replace him as in his position, an AME, an aircraft maintenance engineer. It flew, the employer flew AMEs to provide coverage when necessary, but by November 2020, Orange began to have a discussion with the union about creating a contract AME position in that particular base. So again, trying to do its part in finding alternatives. The employer reached an agreement with the union. They hired a contract AME to work with the other permanent AMEs, such as this griever didn't need to perform those duties. And the employer said it's been difficult to find anyone, and this was accepted by the union. In October 2020, the IMU report found that due to the high quantity of THC consumed, typically 13 to 14 hours before the griever's morning shift, the employee was not fit for duties for his safety-sensitive job. And Dr. Melissa can speak about this in more detail. There were a list of conditions for continued use of cannabis that, if followed, would allow the employee to perform his job duties. The conditions included switching to a CBD dominant product, a cap on THC consumed per day, and the requirement that the griever consume cannabis at least 12 hours before the start of a shift. At that time, there was some information with respect to the on-call work that the griever did that was not shared for the IME, and that caused the need for another report as well. Ultimately, the employer concluded that no accommodation was possible and advised the employee that he could no longer work, and the next step was to apply for disability benefits. In January 2021, in preparation of litigation, the employer then requested the additional report from Dr. Snyder-Adler, and there was lots of recommendations there. The report also noted that no cannabis consumption could be possible on weeks the employee was required to be on call. And it noted that he may be required to look into other non-medication treatments for anxiety during those weeks. In February of 2021, the employer told the griever, after he had been accommodated in a different position, he had been accommodated in his own position with modifications. The employer ultimately told the griever that he had to go home as he was in violation of the alcohol and drug policy. So for a while, the employer continued to pay the griever. The griever ended up going on short-term disability, and then that short-term disability ended as the insurance company was of the view that there was no medical reason for him to remain at work. The employer engaged in additional measures to try to provide income support for the griever, and this is important from the perspective of all of the steps that the employer took to get to where they got, ultimately saying, we can't accommodate and we don't have any work for you. He was paid for a benefit that he wouldn't have otherwise been entitled to, which paid him 75% of his base salary. And then ultimately, around end of September of 2021, the employer told the griever that subject to his satisfactory performance in the role, it had a non-safety sensitive role to offer him for the period of a maternity leave. It was about 20 hours per week, and he would be paid at the rate of an AME, and the griever accepted the position effective October of 2021. The arbitrator found that Orange concluded that since the griever would still be taking medicinal cannabis, that would be contrary to the zero tolerance policy, And so he could no longer be accommodated in an AME job or any other job. And that's where the issue arose. The arbitrator also noted that if the first IME had considered all of the information, including the on-call duties, perhaps the employer could have taken a different approach and noted that the employer's oversight could have been remedied when it found that the recommendations would not work for the griever due to the need to be on call. But instead, the employer concluded that the griever could not be accommodated again. So, as I mentioned, there were two grievances in this decision. One was the grievance with respect to the policy, saying that the policy was unreasonable, and the other one was the individual grievance of the griever for failure to accommodate. With respect to the policy grievance, the arbitrator found that the policy was unreasonable to the extent that it failed to treat prescribed medicinal cannabis as a medication. Whereas the policy said that this policy does not prohibit the use of medications that are taken under the supervision of a licensed healthcare professional, a different standard was applied to medically prescribed cannabis, which was prohibited and subject to the zero tolerance policy. The arbitrator also noted that given the position that Orange was taking, she could not agree with the submissions of Orange that its zero tolerance standard was flexible, because it clearly was not, as the arbitrator found, because Orange said that it had an absolute prohibition on the use of cannabis by those who were in safety sensitive positions, even when, as the arbitrator put it in paragraph 237, even when the expert advises following an individualized assessment of a particular employee in a safety sensitive position, that there is a way for the employee to take prescribed medicinal cannabis but still be fit for duty. Those were the arbitrator's findings. The arbitrator also said, given the position that Orange is taking, I cannot agree with the employer's submissions that the policy is reasonable and therefore allow the grievance from that perspective. With respect to the individual grievance, by the time of the hearing, let's just summarize it. The griever had been unable to work as an AME for over 18 months. And for about 9 months of that, he was not permitted to work at all. The arbitrator found that Orange did not accommodate the griever to the point of undue hardship from February 4th, 2021 and up to the date of the hearing. She also found that the employer had not established that it's bona fide the occupational requirement of the safety sensitive AME job, prohibited using medicinally prescribed cannabis to treat his medical conditions. The arbitrator said that Dr. Melissa's report demonstrated that the zero tolerance standards can be modified without imposing undue hardship on the employer, and as such, that the employer had not met the onus of establishing that the discriminatory standard that they have, zero tolerance, even for the medicinal cannabis, is a bona fide occupational requirement. The medical becomes very important, as it is always in these cases, and a proper understanding of the medical by the employer is key. In this case, the arbitrator said that having conducted an assessment of a particular individual and found him unfit for duty in his current use of medicinal cannabis, there were ways in the report of Dr. Melissa to make himself fit for duty for his safety sensitive job, and that on its own suggested that accommodation was possible. The arbitrator said that there was simply no evidence that in any kind of objective basis, Orange's very steadfast position that in order to accomplish its health and safety objective, it had to completely prohibit the employee from using any kind of medicinal cannabis, it didn't find it reasonable. So the one last aspect before I turn it over back to Jonathan or to Dr. Melissa is that the arbitrator said nothing in this decision should be taken as deciding that the griever can in fact be accommodated. And that's extremely important as well. right? It's not as if the arbitrator said, you should have and could have accommodated him in this specific role. But she says, rather, the decision that I'm making today addresses the fact that the employer breaches duty to accommodate by not even trying. And we'll talk more about this, but that trying is that procedural duty to accommodate. Now, some might disagree and might think that Orange did try quite a bit, but it wasn't enough. Okay, so she says the employer did not even try or permit the griever to try to ensure that he could do the job safely if he was able to live within Dr. Melissa's recommendations. The particular circumstances of that particular base where the work was required and required on-call schedules would have required the griever to not take any form of cannabis for at least the week that he was on call, and potentially at other times when the other AMEs were unable to work. The arbitrator says the griever may find that once he's given a chance to try out Dr. Melissa's recommendations, it might be that it's still not possible to manage his illness under that regime. But the parties needed to address that and any other potential issues that would arise in the attempt to accommodate the griever. And I think that's essential, and I'll leave that with you to think about when we continue to talk about this case.
And thanks very much, Melissa. Yeah, that unpacks a lot of things. I mean, zero tolerance, recreational versus medicinal use, what constitutes safety sensitive, what constitutes a failure to accommodate, and this procedural and substantive bit that we'll hopefully get into in a bit more. But I just want to switch gears and perhaps allow Dr. Melissa, as we're coming to call you today, Melissa, give you a chance to talk a little bit about your perspective on this case and your involvement. So I'll turn it over to you.
Sure, thank you. So, I want to just highlight a couple of things that I think are really important, and that is the difference between recreational cannabis and medical cannabis. So I'm not talking about from a sort of legal sense or accommodation, but more from why we differentiate that in how it impacts and affects an individual. And that really highlights the differences when you're writing policy or dealing with individuals, because you can't rely on information from medical to therefore assume that somebody using recreational could be okay. So I really want to just go through that a little bit. So I think it's important to differentiate it based on intention. So if we think about the intention of a person using a recreational substance in any way, they are using it to get an effect. And what I mean by that is that if you are smoking or vaporizing, they're generally using a bit of a higher dose and using it to get to the effect that they are seeking. Whereas when somebody is using something or cannabis from a medical perspective and a true medical perspective, although they're using it to try to decrease their medical symptoms, they tend to take it in a bit more of what we call steady state. So it's a usually fixed amount, give or take, a couple times a day or a few times a day at specific times in specific doses. And for the most part, there is the avoidance of feeling high, because when you want it from a medical perspective, generally speaking, people don't like that feeling of feeling out of control or high or having it be too much, whereas that is the intention from a recreational perspective. So even when we look at the effects on the brain, it is different when you take people that are using it for legitimate medical reasons in a way that is very prescribed versus somebody who's using it to get the recreational effect. So, when we talk about can you use medical cannabis in a safety sensitive workplace and why the time frame may be different, it's partially because of that intention and the impacts on the brain when you use it in different doses, different amounts, different routes of administration, and achieving a different effect. So again, using more to get to that upper effect of what most people want when they want that recreational use. And so when it comes to recreational, we absolutely 100% still need to fall back on what we have been saying and doing for the last number of years. And that is OMAC, or Occupational and Environmental Medical Association of Canada, OEMAC. They have a position statement for the use of cannabis in the workplace and speak to at least 24 hours with no cannabis use prior to engaging in safety sensitive duties, tasks, or work or a work site. So that from a recreational perspective, absolutely 100% needs to be followed at a minimum. That's sort of the minimum standard. But from a medical perspective, we have to look at it a little bit differently. And that is also to do with the dose. So not all medical cannabis can be accommodated and be able to be used in the workplace. And if you read through the case, you'll see that using the medical cannabis that he was using at the beginning, this individual was found not to be fit to work because the THC dose was too high. But when we can get that THC dose to a very, very minimal amount with a particular time frame before work and used in a particular manner with no other cannabis use or products and no other impairing medications alongside, then we can get to the point where the impact, based on studies to date, the impact of that dose used in that way, in that time frame for specific conditions is likely safe in the workplace. When I say likely safe, it's because we can't say that anything is 100% safe. The safest thing is never to use any medication, any substances ever, but we have to balance that. And then the considered and compared to the alternatives. So what are alternative medications? And there are lots, and some of those are impairing as well. So it is that balance between what's the safest thing. And the other thing that we have to remember is that sometimes the condition itself, whether it's chronic pain or anxiety, can lead to impairments, if not treated, in the workplace, and can lead to risks in the workplace just from the impacts of that illness or medical condition. So it's weighing all of those things, but it is really important to understand that what we are talking about here is not recreational. And from a recreational perspective, we fall back on that at least 24 hours, if not longer. And from a medical perspective, we're talking about tiny doses in a spread out manner with specific routes. So I just wanted to highlight that because I think that's one of the most important things. And just because it's medical cannabis does not mean that it's safe. And you have to really look at the fine details of it. And each individual person is different. Sometimes it has to do with other medications that they're taking at the same time. Sometimes it has to do with the route of administration and how they're taking it. So it is really important to make sure that each individual is assessed on their own, looking at what they have tried in the past, what alternatives there are that may be non-impairing or less impairing, options, dose, route, and really looking at everything, the whole big picture before making that assessment. So it's not black and white, and it is going to differ a little individual to individual.
Thanks, Melissa. Yeah, and so this is a little bit different. 3.5 years ago, after the legalization of THC, we really sort of relied on this 24-hour time frame. No use or no safety-sensitive work for anyone 24 hours after last use. And certainly that's been the case with recreational. When we're talking about medicinal cannabis, what I'm hearing you say is that, in very special circumstances, there actually might be some allowance for this. And so you can't just look at this as a black and white issue. You actually have to dig a bit deeper into this.
Yeah. And the other thing that I do want to mention is that you have to make sure that when it is, or when as an employer, when an employee discloses medical cannabis, that it is actually medical cannabis. There is a difference between buying recreational cannabis and using it for your medical condition versus having a healthcare provider who is following the individual, giving recommendations as to what they're purchasing. They're purchasing it from a Health Canada licensed producer, from the medical, that medical sort of umbrella or the medical side. And where you're looking at the invoices and it's sort of seeing exactly what they're purchasing, so you know what they're using, or hopefully know. I suppose somebody could be using recreational stuff on top of it. That's the tricky part here. But we would do the same thing with prescribed medication. So if this was Tylenol 3 or Percocets or a benzodiazepine, looking at the prescription or the dispensing information from a pharmacy would give us that same information, right? Could they be taking extras? I guess they could be, right? On top of what we know, what's prescribed, what is recommended. So that's the same thing, but it is really important to ensure that what you are talking about is indeed medical cannabis being followed by a healthcare provider, because that is very different from, well, my doctor told me I could use cannabis and I'm buying it at the store and kind of figuring out what I need to make it work for me. That would not be considered medical.
Okay, yeah, thanks for outlining that distinction. We'll get to some of the questions which are addressing some of these issues that you're bringing up. One of the things I want to do is maybe just switch back to Melissa Roth. Melissa, there's some questions coming up and we'll get to the specific ones, but can you just talk a little bit about what this duty to accommodate actually means? What are the limitations? And you briefly touched on this procedural and substantive things. Can you actually unpack that for us a bit?
Absolutely. Okay. So to begin with, it is important to understand that the duty to accommodate only arises in the context of protected grounds and the human rights legislation. So once we have a protected ground, then that means that there's going to be some job or workplace requirement or practice or rule or policy that an employee is unable to meet or to comply with because of their protected grounds. And the duty to accommodate, of course, includes all protected grounds. Today we're talking about disability, but it also includes religion, family status, and all of the other grounds listed under the legislation. In this context, the duty to accommodate is another way of saying that an employer will have to make some changes to those workplace rules, policies, or practices or requirements in order to meet the needs of individual employees that arise from those protected grounds and ensure that the employee who is able to work can do so safely, performing the essential duties of their positions, okay? Essential duties of the position is very important here as well. In some cases, we may also need to look at other positions. As you can see in this case, the larger the employer, the duty to accommodate becomes more onerous when it comes to looking at other positions. Ultimately, it means that individuals cannot be excluded from the workplace on any protected grounds by human rights legislation when the working conditions can be adjusted without undue hardship. So that brings me to the concept of what is undue hardship. And undue hardship is a very, very difficult term to define because there's no specific definition. So, you know, for instance, in the decision, which we will share or have shared the link, at paragraph 263, the arbitrator says, based on the case law, the standard an employer has to meet in order to prove that it cannot accommodate an employee without undue hardship is high. Then the arbitrator goes to distill what the Supreme Court of Canada has said in different decisions as to what constitutes undue hardship. And it made some really good points, and it's summarized in 4 bullet points. The use of the term undue infers that some hardship is acceptable. It is only the undue hardship that satisfies this test, meaning employers are always going to experience some hardship, some cost, and some inconvenience when they're accommodating human rights protected needs. Number 2 is that the employer or service provider has made every possible accommodation short of undue hardship. And that's why I say, you know, it's a very difficult concept to define, because who's to decide that they've done every possible accommodation? As in this case, they thought they did it, but the arbitrator thought otherwise. They could have gone an extra step. Number 3 is there has to be no reasonable alternatives available, and that relates to the prior point, right? If a reasonable person would think that we could have taken one more step, then there are reasonable alternatives available. And number 4 is where an employer or service provider shows that it could not have done anything else reasonable or practical to avoid the negative impact on the individual. Then the point of undue hardship is reached when any reasonable means of accommodation are exhausted and only unreasonable or impracticable options for accommodation remain. The other part of your question was about procedural and substantive duty to accommodate. And that's important because very, very often, employers or service providers forget about the importance of the procedural duty to accommodate. So the procedural duty to accommodate is, how do we do what we're supposed to do? And the substantive duty to accommodate is the actual outcome. Did we reach the proper outcome? Did we accommodate or not? And the procedural duty to accommodate is even more important than the substantive duty. Damages can be awarded even when an adjudicator would decide that the employer reached the appropriate outcome, i.e. they met the duty to accommodate, but they did not engage in the procedural duty to accommodate. And that's very important to understand. So there is a need to engage in a meaningful inquiry of the individual employee's needs and how they can be accommodated, whereas the substantive duty requires that appropriate accommodations be implemented where possible without undue hardship. It is important to recognize that even when there is ultimately no appropriate accommodation, the employer can implement and has to engage in a process where they take all of the reasonable steps to assess the employee's needs and consider that accommodation. Failure to do so can result in liability from either one of those two failures to meet either one of those parts of the duty to accommodate.
Okay, great. Just looking through some of these questions that are coming up, and one of the questions talks to this. So maybe I'll just summarize this question, perhaps throw this back to you. I think that you've addressed this, but in a company with many positions that offer that an employer has to offer, but they're a commercial truck driving organization without any other positions. They do have a mechanic shop that requires that there could be some unlicensed positions to accommodate. In that manner, where you have a very prescribed job, and if a truck driver can't drive a truck, is it a requirement for that employer to put them into a mechanic shop, even though they may not have the right full training or the licensing or whatever it is?
Excellent question. So when it comes to the duty to accommodate, adjudicators tell us we have to look at the employee's own position first. And then, as I mentioned, the larger the employer, the more onerous the duty becomes. So we start with their own position. Then we move on to a different position within the same department. If the employer is large enough, I'm going to go with the largest because this is going to give you the most onerous standards. Different position within the same department. And then if we can't find anything there, we go to a different position in another department or division of the employer. However, the important part here is that we need to meet two things. The position that we're looking for this employee has to, number one, be within the restrictions and limitations that the healthcare professionals have established for this employee. Remember, healthcare professionals don't tell the employer how the employer has to accommodate. Healthcare professionals guide us with restrictions and limitations and can give alternative solutions or potential solutions, but it is ultimately the employer, the one that has to find the proper accommodation. So the position has to be within the restrictions and limitations of the employee. And number two, just as important, it has to be a position that the employee is qualified for, that they have all of the requirements, qualifications, and experience and skills to perform the position. So if we don't have a position within the restrictions and limitations that the employee can perform within their skills and qualifications, then we have no way to accommodate.
Okay, great. So maybe to Dr. Melissa, this question comes up: how long is a person impaired by use of cannabis, and can they be impaired to some level the next day if they've taken cannabis the previous night? Can you unpack that for us?
Yeah, that's a good question. So, what I will tell you is that there are hundreds of factors that determine how long each individual person will be impaired by cannabis. And so there is no easy answer. But what I will tell you, and when it comes to, workplace and safety sensitive industries, that we need to look at the risk, because you cannot say For alcohol, we can say it's about the same for each person. We know we eliminate, or we get rid of about a drink per hour. So you can figure out for almost anybody when they've last had alcohol, and therefore when it would be out of their system and they would be fit for duty. We cannot do that for cannabis at all, because there are just way too many factors that play a role in impairment. We have studies that show that impairment can last for days to weeks, even up to 28 days in some circumstances. That's generally for people who have been using very heavily over a long period of time. So if a person just has it once in their entire life, I wouldn't necessarily expect that they would be at risk for 28 days, but we don't always have that information. Meaning, we can't say to somebody, well, if you use this amount, and if you take it here, and if your history is this, and if you have no other medication, and if your metabolism is this way, there's just too many factors. And so, depending on what the position is, depending on, what we're really talking about, what the work site is, what the risks are, et cetera, is where you sort of lay that line. When I talked before about 24 hours, that's where that minimum would be, that highest risk is in those first 24 hours. That does not mean that at 25 hours, there's zero risk for every single individual. Nor does that mean that every single individual who used cannabis will 100% be impaired at 24 hours. But again, that risk is the highest within 24 hours. So there are certain industries where 28 days is sort of the regulation. And when I say regulation, I'm talking about, for example, airline pilots, flight crew, et cetera. In this particular case that we're talking about, that position did not fall under those regulations by Transport Canada. And therefore, that's where the issue came in. But, so what I will say is that there's no easy answer. Impairment can last for many, many days to weeks, and that highest risk is in that first 24 hours. Although again, that doesn't confirm that each individual person is 100% impaired, but we are looking at risk and mitigating risk when it comes to safety sensitive industries and doing the best that we can to mitigate all risks and hazards in the workplace.
Okay, great. I'm going to combine a bunch of questions because I think that they're talking about a few of the same concepts. And the questions are really, how can we accurately measure the THC concentration before somebody starts duties? How can an employer be aware of the right amount of THC that's medically authorized? What happens if somebody uses more than what their doctor has prescribed? And then on the back end of that, perhaps also we'll get to Melissa Roth perhaps, but who can actually prescribe this? Do we just take it from a family doctor or anybody else? And then can the employer challenge those diagnoses for which something is being prescribed? So maybe we just start off on, is there an accurate way to measure this therapeutic level or this concentration that might be that some place might be able to accommodate?
Yeah, so it's a good question. So generally speaking, when we're talking about limiting the THC, and in the workplace, when we're talking about it, we're talking minimal dose of THC at 12 hours, but with a maximum dose that they can have within 24 hours, meaning, at 13 hours before work, you can't be having 7 joints and then, then not having anything for very high doses, let's just say very, very high doses of THC, and then not having anything for 12 hours. That would not work. And so we sort of limit the amount within 24 hours and then no use within 12 hours. And when you do that, we can use oral fluid testing, the swab test that we do, with a higher cutoff level of 10 nanograms per mil, because at that, you are not going to test at 10 or above when they're using minimal THC, because we're only talking a couple milligrams of THC, like not very much, very, very low, with more than 12 hours in between. So what some employers who do testing have done is said, okay, well, we're going to, on a sort of unannounced, testing, we're going to just kind of do testing sporadically, and we're going to just double check that your tests are not going to be above 10. And if they are above 10, then that is an indication that they are not following the protocol. They're either using a higher amount of THC or they're using it closer to the time frame of the test. And so that's a good way to sort of test that and manage that if you're able to, and if testing is sort of part of what your policy and what you're allowed to do, et cetera, and what has been agreed to, but that works well from that perspective. I feel like you would ask something else, Jonathan, but now I don't remember, sorry.
Yeah, so, to bounce on that, so you use oral fluid testing to try to get that shortest window to try to determine when the last use was, and then by extension, probably impairments lasting for around that time. The other questions that relate to this is, well, who prescribes this stuff? Do we have to take the family doctor? Do you have to have a specialist do this? And then once we do that as an employer, can you actually challenge that if it's being prescribed for something that maybe is off label or hasn't been sort of there's very little evidence, medical evidence to support that. So maybe we'll get your take, Dr. Melissa, and then maybe Melissa Roth's on how employers can face that.
Yeah, so as long as the person is a healthcare provider, it's hard to know, obviously, what their experience is, meaning you can have a family physician who this is all they do is medical cannabis and they are sort of experts in their field. You can have others who may have one patient and that's what they're doing. So that's a little challenging, and I understand that. With respect to medical conditions, so, I know there are guidelines out there, but they are not the be all and end all. And what I mean is that physicians and healthcare providers can authorize cannabis for a whole host of medical conditions. And what I will say is that the kind of, the big picture is that this is not a first-line therapy, nor should it be a first-line therapy. So other therapies for any condition we're talking about should have been trialed and either found not to be effective or to have intolerable side effects before considering cannabis for basically almost any condition. There are many medical conditions out there where we don't have big studies because they may be rare medical conditions. We may have anecdotal information, a study of one person who took it for a very rare condition and it seemed to help. And, if that person has tried other things and they choose to try cannabis, we can't say that that's not appropriate. So there may not be a lot of medical evidence for it, but there's not evidence against it. There's just not evidence yet out there. And so again, it's making sure that other things have been trialed, looking at alternatives the same way we do with all accommodations, right? What are the alternatives that would be non-impairing or would allow them to be able to do the duties of their job? Are there other options? And often there are, not all the time. Often there are that have not been tried. And so that would sort of be part of the whole thing. But, I'll leave it to Melissa to really unpack how much of that you can really say that has to be done and take issue with. So I'll turn it over to you.
Thank you. So going back to the original question, is it whether we can, are we going along the lines of whether we can insist that other medications be tried before medicinal cannabis as an employer, like take that position? If that's the question, the answer will be, it depends, right? So, depending on the circumstances, we're going to be able to say, with the problem is this, I'm going to back up one step further. If you get medical from a qualified healthcare professional that says so-and-so needs to consume medicinal cannabis for the treatment of their disability, because remember, you're not even entitled to the diagnosis. If you're going to challenge that medical, then you better get your own experts to challenge that medical. Or you can try challenging it, and then you're going to have to engage in the discussion and then the back and forth with the employee. Because at the end of the day, I, as a lawyer, or one of my clients as a human resources person, do not know. We don't have the knowledge to challenge what's in that medical. So we can try. We can ask the question, have you tried any other medications first? We can ask the doctor if they have tried other medications, and we can ask if there's other options. But it doesn't mean that that on its own is going to extinguish the employer's duty to accommodate.
Oh, so it's often a challenge then for employers if a licensed medical professional has authorized use for them to challenge it easily?
Yeah, I mean, and you're going to have to enter the inquiry, right? Like I had cases where I'll tell you two diametrically opposed cases. In one case, we wrote back to the doctor and we said, this person works in this safety sensitive position. They operate heavy machinery and mobile equipment. This is an essential duty of their position. This is all they do all day. I understand you've prescribed him with medicinal cannabis. Can you confirm that this will not cause impairment, that the cannabis that is being used will not cause impairment? The doctor responded with, I was not the one who prescribed it. And, and I cannot answer your questions. So that employee very quickly abandoned the request for accommodation. I also had another case on the opposite side of the spectrum where I asked all kinds of questions to the medical professional, and the response came back saying, the strain that is being used is CBD dominant, and sort of along the lines of what Dr. Melissa was saying before, and I'll defer to her with respect to any more detail on that. But the doctor said CBD dominant should not cause impairment. He should not smoke it, before this and that, and came up with all kinds of parameters. And we tried it, and we at no point did we identify impairment. Or fitness or no fitness for duty, right? Because at the end of the day, what we have to remember, and this goes back to your original question to Dr. Melissa, is that there's tons of medications that can cause impairment if they're not taken properly. If somebody's prescribed Percocets and they are abusing them, they're going to be impaired. And even if and Dr. Melissa might say, even if they're not abusing them, they can cause impairment, right? But that fear of, well, this person was prescribed medicinal cannabis, but how do I know that they're not using it recreationally too, is the same as with any other medication. The point of this case and of today is to try to turn our minds to the fact that we can't treat it differently from other medication that is prescribed by a healthcare professional.
Yeah, and I think that's a good lesson for employers to learn that, take away the emotion that goes along with cannabis use. If it's medicinally authorized, then you've got to treat this as you would any other prescription medication and accommodate in that fashion. There's a bunch of questions on trucking that I want to get to. They're pretty easy to answer. Probably, Dr. Melissa, I'll look to you. So the questions are, does this apply to U.S. Department of Transportation? What about truckers that are going across the border where DOT has zero tolerance, so you can't have any of this, regardless of whether you have authorization or not? How do you approach that? So very briefly, are you able to sort of tell us a little bit about that part?
Very briefly, it is zero tolerance, end of story, and the US DOT federal regulations will override anything that we are talking about here. So meanwhile, whether it is medically authorized, whether it's used recreationally in a legal country, legal state, et cetera, they cannot have any THC in their system to be able to drive cross-border, essentially, end of story. So if they have medical cannabis, that they cannot work as a US DOT driver. They do not have clearance, and US DOT does not consider that at all. So it's sort of an easy question. That is a case where it is completely black and white. I'm not going to speak from a legal perspective, but that's just the federal regulations, black and white, end of story.
So just to throw a little bit of gray into this, though, you have a Canadian driver who's going across the border to the US. So they can't go across the border to the US. It's not permitted. But they're a Canadian driver. Does that trucking company have to then look at accommodating them to just go across Canada?
I'm going to leave that to Melissa, because that's a legal question.
And that's very specific.
Right.
I would say, and I have been answering some of the questions that are in the Q&A. But there are a lot of questions that are specific legal advice. And for that, I'd be happy to consider a situation like that, but I need to know all of the circumstances. We need to know in your case and what you just explained, perhaps, right? If there are positions that are within the country and that do not breach those additional regulations, and the employee is qualified to perform them and they're within the restrictions and limitations, then perhaps you have to look into that. Yeah.
Okay, great. So we just have a few minutes left. I want to try to get to some of these questions. Perhaps while I'm looking through some of these questions that are coming up, Dr. Melissa Roth, are you able to think about sort of the takeaways for some of these employers? Like, what should you take away from this case? What should you learn from this? Perhaps I'll go back to Melissa Roth for that.
Okay, so one of the very important things is to not think that we can develop, and there's been questions in the Q&A and I answer some of them. You don't think that you can develop a blanket policy that has a zero tolerance across the board, no matter what. You're going to fail in your duty to accommodate. You're going to fail in the, if it's a unionized workplace, the policy will be unreasonable because it doesn't take into consideration the duty to accommodate and the potential for disabilities. So that's one thing that it is important. The other very important takeaway is to understand the medical, to make sure that when you're asking for a medical report or additional medical information, you're providing the doctor, the healthcare professional, with all the details of the person's position. Because, and I don't want to speak for Dr. Melissa, but a doctor cannot make an assessment in a vacuum. They need to know exactly what for instance, we often include job descriptions where the doctor can see what the circumstances of that particular employer are. So that's another very important takeaway. And I would say that, the last one is to ensure that when you're building a policy, you're doing it in a way that is reasonable, that doesn't forget about the duty to accommodate, and that you don't treat certain medications differently from other medications. I understand perhaps there's a dispute as to whether medicinal cannabis is considered a medication, I can properly call it medication or not, but if it's something that is used for the purpose of treatment of a disability, let's put it that way, let's treat it all the same way. We can't have, preconceived notions of what something is or does, and for that reason, treat it differently than another treatment.
Yeah, it's a great takeaway. Maybe over to Dr. Melissa, any big takeaways that you'd sort of advise employers to keep mindful of?
Yeah, so, the big one is that regardless of what the individual says, or even truthfully what their own physician says, because I will often get reports back from physicians saying the person is only using CBD, they are totally safe. And when I look at the purchases of what they're making, there's like no THC on there and very high THC. So it's really important to go through the full assessment of each individual person, their history, the medications they've tried, the therapies they've tried, what they exactly are purchasing, what they are using, doing the calculations of the THC and making a determination. So, I don't want to say don't trust the doctors or healthcare providers who are authorizing the cannabis, but they are not. They don't have that knowledge of occupational health and safety. So you definitely want to get an opinion from somebody who has that insight and knowledge, and can also take a look at exactly what that employee is using, including other medications or substances, to be able to get that whole picture and go through that for each individual person, because every situation is different. And, and it also depends on the position and the industry and all of that with respect to whether or not this can be accommodated. So I just think it's really important to ensure that you are getting the right review and information on each individual person.
Thanks very much for that. I'm just mindful of time. We're coming up to the top of the hour. There are a ton of questions. We are certainly not going to get to them today, but hopefully we're able to provide some answers. Jeremy, you can correct me if I'm wrong, but we hope to provide some written answers to some of the questions that we could sort of farm out to everyone who's attending this discussion. Takeaways, certainly workplace accommodation. You're not absolved just because somebody's got cannabis, and especially if it's medicinal cannabis. You really have to pay attention to that. The details of the case really matter. The job description, the hours of work, the on-call duties, all of that stuff really matters. So when you are reaching out to your legal counsel, when you're reaching out to your medical experts to give you advice, please provide them with all of the information so they can make a proper evaluation and can advise employers properly. So with that, maybe I'll turn it over to Jeremy, but on behalf of Driver Check, from my perspective, thank you, Melissa Roth. Thank you, Dr. Melissa Schneider-Adler. Really appreciate you both weighing in on this case that's generated a ton of questions. We hope to have some of that pushed out to our attendees. Over to you, Jeremy.
Okay. Yeah, and again, just to follow up on Jonathan's comments, what a fabulous discussion from the three of you. So thank you so much. It's been so long since we've talked about anything outside of COVID. So now I'm having flashbacks from when cannabis was being legalized. And we use, because it's such a fluid landscape with so many different scenarios, we do typically say, you know, you might come away with more questions than answers, but at least you're asking the right questions. I think that's where a lot of the premise is around. So just to remind everyone, later today, we'll be sending out a survey. We'd love to hear your feedback. That's why we hold these sessions, to get your feedback, make sure we're providing valuable content on topics that you're interested in. So we'll send that. So please respond. And then by the end of the week, we hope to send out a recording of the, publishing the link for this recording, and we'll be posting on YouTube. So we'll send an email out to all the registered guests. And then I would expect it to be sometime next week by the time we can, we have 60 open questions here according to my Q&A icon. A lot of them do overlap and we have touched on it, but what I'll do is I'll work with the Melissas and Jonathan to get those back to you in a quick fashion, but we'll aim to do that next week. So with that, I bid everyone farewell and thank you for everyone in attending today.
Thanks, everyone.
Take care.